You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
Today's case is a roller coaster of legal drama, emotional confessions, and one defendant's fight to convince the court he deserves one more chance. Meet Samuel Peoples, a man facing serious felony charges for tether tampering, a violation that could land him back behind bars for months, maybe even years. But here's where it gets complicated. Yes, Samuel cut off his tether, but according to him, he didn't flee. He claims it was an anxiety attack, a moment of claustrophobic panic. That explanation alone is going to raise eyebrows. The court's about to weigh mental health concerns against public safety, and both the prosecution and defense are ready to dig in. By the end of this hearing, we'll see whether judge decides Samuel walks out the door or stays locked up. And trust me, the way this unfolds will have you questioning whether the legal system should show mercy or stand firm. So buckle in, this one gets tense fast.
Court does call the cases of the people versus Samuel Peoples.
Thank you, Richard. People.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, in file 1326, Mr. Peoples has not yet been referred to the Forensic Center. I've prepared an order.
Right here, we see the defense pushing for a forensic examination. In legal terms, this isn't about solving the crime. It's about assessing the defendant's mental competency to stand trial. The court needs to know, does Samuel fully understand the charges against him, and can he participate in his own defense? This is crucial, because if he's found incompetent, the trial pauses until treatment restores his capacity. These exams can dramatically alter the timeline of a case, sometimes buying months of delay, and that's exactly the kind of breathing room the defense might be counting on.
And we are asking the court to order a forensic examination. In that case,
All right, I will order a forensic examination without objection. On that case, what is my next date? Let's see now. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just
That was last week. All right. So set a competency here, October 2025, 9 a.m. All right. What are we doing on the other case?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326.
Well, also arose with tether.
Which is charged as a felony, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's listed.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether.
And here's the big reveal. Samuel didn't just violate bond, he allegedly cut his GPS tether. In most jurisdictions, that's a serious felony on its own. Prosecutors argue that tether tampering undermines the entire concept of pretrial release. It's meant to guarantee a defendant's location. But here's the twist. Samuel didn't leave the premises. When police arrived, he was right there. That changes the narrative. Was this an escape attempt? Or exactly what he says, a panic-induced breakdown? That question is going to decide whether the judge sees Samuel as a flight risk or just a man who made a terrible decision in a moment of anxiety.
But he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I thought anxiety.
Response?
Your Honor, obviously we had an extended conversation about this at bench at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that, given that we have this incident, I don't know how sufficient that's going to be, but I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're going to cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before you just did it?
I had a moment of,
Listen closely here. The judge calls Samuel out directly. You understood it before, you just did it. This is judicial reality check mode. Judges hear every kind of excuse imaginable, so emotional explanations like anxiety need to be backed up with evidence or a documented history of mental health struggles. While the judge shows some empathy, there's also a subtle warning. I'm watching you, and I expect compliance. The tension here isn't just legal, it's personal. The court's essentially saying, I might give you a second chance, but if you blow it, there won't be a third.
anxiety that led to a freak out. Yes. And I felt like I needed to get it off me because it was claustrophobic. And
Got it.
yes.
I hear you. Okay. All right. Here's going to be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap. Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
All right. Samuel,
Yes, Your Honor.
I give you another shot. You're going to try to do the right thing?
Yes.
Okay.
Thank you, Your Honor.
All right. I'm going to do it. I think you can do it.
Me too.
Okay.
All right.
Got it?
Thank you.
So what's going to happen is somebody's going to have to pay money for the strap that got damaged on your tether.
Understand.
I'm going to reinstate your previous bond where you were previously at home, right?
Mm-hmm.
And then they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right. Thank you, Your Honor.
Okay. Don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After
Sure.
consulting with Mr. People's family, they are asking the court if
This is an unusual and deeply human moment. Samuel's family asks for permission to take him to a hospital if he has a crisis, without it counting as a violation. On paper, this sounds reasonable. In practice, it's tricky. Every movement outside home confinement has to be logged, and emergency exceptions can open the door to misunderstandings or abuse of the privilege. The prosecutor's pushback here is telling. They're worried about setting a precedent. If one defendant gets leeway for unsupervised outings, others might expect the same. What's fascinating is how this conversation blurs the line between the rigid rules of the court and the unpredictable realities of mental health management.
if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor, without necessarily violating a confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the tether agent if that arises.
Response.
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office, so that the court would be apprised of what was happening. But the tether conditions, I believe, want to remain the same.
Actually, what happened last time was the public defender came up on Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Jade, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told and I made it very clear, we'll bring him in here, because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request is for a tracking tether change.
Stop talking. You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
We're grabbing Mr. Wondering right now.
Your Honor, I'm very familiar with Mr. Peoples' case if the court wants to proceed.
All right. Ms. Douglas is now here on behalf of people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond.
Now we see the judge making a critical move, aligning the bond in Samuel's new felony case with the one from his previous charges. This isn't just administrative housekeeping. It's the difference between Samuel walking out of jail and sitting there until trial. But freedom comes at a literal price. $175 for a replacement tether strap, payable before release. To some viewers, that might sound minor. In reality, court-related costs like this can add up fast, especially for families already stretched thin. This is the justice system in action. Freedom is possible, but it's not free.
I'm going to make his bond in his new case match the bond with the conditions in his other case, so that he can be released, because otherwise he would be held on that. He'll be refitted with a tether on, he'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid, and all prior conditions are reinstated. And then we need a new date. So when do we?
Your Honor, my request.
Well, I got the confident. It's actually going to be October 30th.
Okay.
It's going to be our day. So, all right.
Thank you, Your Honor. May I provide the court with the order to undergo forensic?
There hasn't been enough on this case yet, Mr.
I'm not.
Oh, go ahead.
May I approach?
Yes.
Thank you.
What is this? No, that's the
Thank you.
order on the other case. I'm sorry. Not a problem.
Might be tomorrow, but as soon as they put the tether on you.
Here's the moment of truth. Samuel gets his second chance. The judge reinstates his previous home confinement with GPS monitoring. All conditions are back in play, and the message is crystal clear. Comply 100% or the next stop is jail. This is a calculated risk for the court. They're betting that Samuel's anxiety won't lead to another violation. For viewers, this is where the debate begins. Is the court right to show leniency here, or is this a gamble that could backfire? Let me know in the comments. Should tether tampering ever be forgiven?
Okay.
Sounds good.
Okay. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're gonna do it, right?
Yes, Your Honor.
All right. That's good. Thank you.
And that's the close on the People versus Samuel Peoples. In just a few minutes, we saw a case that balanced law, psychology, and second chances. On one hand, tether tampering is a felony that undermines the court's trust. On the other, the judge recognized the role anxiety played, choosing to give Samuel another shot rather than lock him up. Whether you see that as compassion or a risky move probably says a lot about how you view justice. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.